Undertaking for cost. E. The indenture to be qualified shall automatically be deemed, unless it is expressly provided therein that any such provision is excluded, to contain provisions to the effect that all parties thereto, including the indenture security holders, agree that the court may in its discretion require in any suit for the enforcement of any rights or remedy under such indenture, or in any suit against any trustee for any action taken or omitted by it as trustee, the filing by any party litigant in such suit of an undertaking to pay the cost of such suit, and that such court may in its discretion assess reasonable costs, including reasonable attorney's fees against any party litigant in such suit, having due regard to the merits and good faith of the claims or defenses made by such party litigant, provided that the provisions of this subsection shall not apply to any suit instituted by such trustee, to any suit instituted by any indenture security holder or group of indentured security holders holding in the aggregate more than 10% in principal amount of the indentured securities outstanding, or to any suit instituted by any indenture security holder for the enforcement of the payment of the principal of or interest on any indentured security on or after the respective due dates expressed in such indenture security. Directions and waiver by bondholders prohibition of impairment of holders' rights to payment. Section 316. A. The indenture to be qualified. 1. Shall automatically be deemed, unless it is expressly provided therein that any such provision is excluded, to contain provisions authorizing the holders of not less than a majority in principal amount of the indentured security, or if expressly specified in such indenture, of any series or of securities at the time outstanding. A. To direct the time, method, and place of conducting any proceedings for any remedy available to such trustees, or exercising any trust or powers conferred upon such trustee under such indenture. Or B. On behalf of the holders of all such indentured securities, to consent to the waiver of any past default and its consequences. Or 2. May contain provisions authorizing the holder of not less than 75% in principal amount of the indentured securities, or if expressly specified in such indenture, of any security of any series of securities at the time outstanding, to consent on behalf of the holders of all such indentured securities to the postponement of any interest payment for a period not exceeding 3 years from its due date. For the purposes of this subsection and paragraph 3 of subsection D of section 315, in determining whether the holders of the required principal amount of indentured securities have concurred in any such direction or consent, indentured securities owned by any obligor upon the indentured securities, or by any person directly or indirectly controlling or controlled by or under direct or indirect common control with any such obligor, shall be disregarded, except that, for the purposes of determining whether the indentured trustee shall be protected in relying on any such direction or consent, only indentured securities which such trustee knows are so owned shall be disregarded. B. Notwithstanding any of the provisions of the indenture to be qualified, the right of any holder of any indentured security to receive payment of the principal of and interest on such indenture security on or after the respective due dates expressed in such indentured security, or to institute suit for the enforcement of any such payment on or after such respective dates, shall not be impaired or affected without the consent of such holder, except as to a postponement of an interest payment consented to as provided in paragraph 2 of subsection A, and except that such indenture may contain provisions limiting or denying the right of any such holder to institute any such suit, if and to the extent that the institution or prosecution thereof, or the entry of judgment therein would, under applicable law, result in the surrender, impairment, waiver, or loss of the lien of such indenture upon any property subjected to such lien. C. The obligor upon any indenture qualified under this title may set a record date for purposes of determining the identity of indentured security holders entitled to vote or consent to any action by vote or consent authorized or permitted by subsection A of this section, unless the indenture provides otherwise. Such record date shall be the later of 30 days prior to the first solicitation of such consent of the date of the most recent list of holders furnished to the trustee pursuant to sections 312 of this title prior to such solicitation. Special powers of trustees, duties of paying agents. Section 317, the indenture trustee shall be authorized, 1, in cases of default in payment of the principal of any indentured security, when and as the same shall become due and payable, or in the case of default in payment of the interest on any such security, when and as the same shall become due and payable, and the continuance of such default for such period as may be prescribed in such indenture, to recover judgment in its own name and as trustee of an express trust against the obligor upon the indentured securities for the whole amount of such principal and interest remaining unpaid, and 2, to file such proofs of claim and other papers or documents as may be necessary or advisable in order to have the claims of such trustee and of the indentured security holders allowed in any judicial proceeding relative to the obligor upon the indentured securities, its creditors, or its property. B. Each paying agent shall hold in trust for the benefit of the indentured security holders or the indentured trustee all sums held by such paying agent for the payment of the principal of or interest on the indentured securities, and shall give to such trustee notice of any default by any obligor upon the indentured securities in the making of any such payment. Effect of prescribed indentured provisions. Section 318A. If any provisions of the indenture to be qualified limits, qualifies, or conflicts with the duties imposed by operation of subsection C of this section, the imposed duties shall control. B. The indenture to be qualified may contain, in addition to provisions specifically authorized under this title to be included therein, any other provisions the inclusion of which is not in contravention of any provision of this title. C. The provisions of sections 310 to and including 317 that impose duties on any person, including provisions automatically deemed included in an indenture, unless the indenture provides that such provisions are excluded, are a part of and govern every qualified indenture, whether or not physically contained therein, shall be deemed retroactively to govern each indenture heretofore qualified, and prospectively to govern each indenture hereafter qualified under this title, and shall be deemed retroactively to amend and supersede inconsistent provisions in each such indenture heretofore qualified. The foregoing provisions of this subsection shall not be deemed to affect the inclusion by retroactive amendment or otherwise in the text of any indenture heretofore qualified of any of the optional provisions contemplated by sections 310B1, 311B, 314D, 315A, 315B, 315D, 315E, or 316A1. Rules, regulations, and orders. Section 319A. The Commission shall have authority from time to make, issue, amend, and rescind such rules and regulations and such orders as it may deem necessary or appropriate in the public interest or for the protection of the investors to carry out the provisions of this title, including rules and regulations defining accounting, technical, and trade terms used in this title. Among other things, the Commission shall have authority, one, by rules and regulations to prescribe, for the purposes of subsection 310B, the method to be fixed in the indenture to be qualified under this title of calculating percentages of voting securities and other securities. Two, by rules and regulations to prescribe the definitions of the terms cash transaction and self-liquidating paper, which shall be included in indentures to be qualified under this title, which definition shall include such of the creditors' relationships referred to in paragraph 4 and 6 of subsection B of section 311, as to which the Commission determines that the application of subsection A of such section is not necessary in the public interest or for the protection of the investors, having due regard for the purposes of such section, and 3, for the purposes of this title, to prescribe the form or forms in which information required in any statement, application, report, or other document filed with the Commission shall be set forth. For the purposes of its rules and or regulations, the Commission may classify persons, securities, indentures, and other matters within its jurisdiction and prescribe different requirements for different classes of persons, securities, indentures, or matters. B. Subject to the provisions of Chapter 15 of Title 44, United States Code, and regulations prescribed under the authority thereof, the rules and regulations of the Commission under this title shall be effective upon publication in the manner which the Commission shall prescribe, or upon such latter date as may be provided in such rules and regulations. C. No provision of this title imposing any liability shall apply to any act done or omitted in good faith in conformity with any rule, regulation, or order of the Commission, notwithstanding that such rule, regulation, or order may after such act or omission be amended or rescinded or be determined by judicial or other authority to be invalid for any reason. Hearing by Commission, Section 320. Hearing may be public and may be held before the Commission, any member or members thereof, or any officer or officers of the Commission designated by it, and appropriate records thereof shall be kept. Special power of the Commission, Section 321A, for the purposes of any investigation or any other proceedings which, in the opinion of the Commission, is necessary and proper for the enforcement of this title, any member of the Commission or any officer thereof designated by it is empowered to administer oaths and affirmations, subpoena witnesses, compel their attendance, take evidence, and require the production of any books, papers, correspondence, memorandum, contracts, agreements, or other records which the Commission deems relevant or material to the inquiry. Such attendance of witnesses and the production of any such books, papers, correspondence, memorandums, contracts, agreements, or other records may be required from any place in the United States or in any territory at any designated place of invitation or hearing. In addition, the Commission shall have the powers with respect to investigations and hearings, and with respect to the enforcement of and offenses and violations under this title and rules and regulations and orders prescribed under the authority thereof provided in sections 22B and 22C of the Securities Act of 1933. B. The Treasury Department, the Comptroller of the Currency, the Board of Governors of the Federal Reserve System, the Federal Reserve Banks, and the Federal Reserve Deposit Insurance Corporation are hereby authorized under such conditions as they may prescribe to make available to the Commission such reports, records, or other information as they may have available with respect to trustee or trustees or prospective trustees under indenture qualified or to be qualified under this title, and to make through their examiners or other employees for the use of the Commission examinations of such trustees or prospective trustees. Every such trustee or prospective trustee shall, as a condition precedent to qualifications of such indenture, consent that reports of examination by federal, state, territorial, or district authorities may be furnished by such authorities to the Commission upon request thereof. Notwithstanding any provisions of this title, no report, records, or other information may be made available to the Commission under this subsection. No report of an examination made under this subsection for the use of the Commission. No report of an examination made of any trustee or prospective trustee by any federal, state, territorial, or district authority having jurisdiction to examine or supervise such trustee. No report made by any such trustee or prospective trustee to any such authority, and no correspondence between any such authority and any such trustee or prospective trustee shall be divulged or made known or available by the Commission or any other member, officer, agent, or employee thereof to any person other than a member, officer, agent, or employee of the Commission, provided that the Commission may make available to the Attorney General of the United States, also the alien property custodian, in confidence, any information obtained from such records, reports of examination, other reports, or correspondence, and deemed necessary by the Commission or requested by him for the purposes of enabling him to perform his duties under this title. C. Any investigation or prospective trustee or any proceeding or requirement for the purpose of obtaining information regarding the prospective trustees under any provision of this title shall be limited to 1. To determining whether such prospective trustee is qualified to act as trustee under the provisions of subsection B of section 310. 2. To require the inclusion in the registration statement or application of information with respect to the eligibility of such prospective trustee under paragraph 1 of subsection A of such section 310, and 3, to requiring the inclusion in the registration statement or application of the most recent published report of condition of such prospective trustee as described in paragraph 2 of such subsection A, or if the indenture does not contain the provisions with respect to combined capital and surplus authority authorized by the last sentence of paragraph 2 of subsection A of section 310, to determining whether such prospective trustee is eligible to act as such under such paragraph 2. D. The provision section 4B of the Securities Exchange Act of 1934 shall be applicable with respect to the power of the Commission. 1. To appoint and affix compensation of such employees as may be necessary for carrying out in its function under this title, and 2. To lease and allocate such real property as may be necessary for carrying out its functions under this title. Court review of orders, jurisdiction of offenses and suits. Section 322A, orders of the Commission under this title, including orders pursuant to the provisions of Section 305B and 307C, shall be subject to review in the same manner, upon the same conditions, and to the same extent as provided in Section 9 of the Securities Act of 1933, so with respect to orders of the Commission under such act. B. Jurisdiction of offense and violation under the jurisdiction and venue of suits and actions brought to enforce any liability or duty created by this title, or any rules or regulations or orders prescribed under the authority thereof, shall be as provided in sections 22A of the Securities Act of 1933. Liability for misleading statements. Sections 323A. Any person who shall make or cause to be made any statement in any application, report, or document filed with the Commission pursuant to any provision of this title or any rule, regulation, or order thereunder, which statement was, at the time and in the light of the circumstances under which it was made, false or misleading with respect to any material fact, or who shall omit to state any material fact required to be stated therein or necessary to make the statements therein not misleading, shall be liable to any person not knowing that such statement was false or misleading, or such omission, who, in reliance upon such statement or omission, shall have purchased or sold a security issued under the indenture to which such application, report, or document relates for damages caused by such reliance, unless the person sued shall prove that he acted in good faith and had no knowledge that such statement was false or misleading, or of such omission, a person seeking to enforce such liability may sue at the law at law or in equity in any court of competent jurisdiction. In any such suit, the court may, in its discretion, require an undertaking for the payment of the cost of such suit and assesses reasonable cost, including reasonable attorney's fees against either party litigant, having due regard to the merits and good faith of the suit or defense. No action shall be maintained to enforce any liability created under this section unless brought within 1 year after the discovery of the fact constituting the cause of action and within 3 years after such cause of action occurred. B. The rights and remedies provided by this title shall be in addition to any and all other rights and remedies that may exist under the Securities Act of 1933 or the Securities Exchange Act of 1934 or the Public Utility Holding Company Act of 1935 or otherwise at law or in equity, but no person permitted to maintain a suit for damages under the provision of this title shall recover through satisfaction of judgment in one or more actions a total amount in excess of his actual damages on account of the act complained of. Unlawful representation, sections 324. It shall be unlawful for any person in offering, selling, or issuing any security to represent or imply in any manner whatsoever that any action or failure to act by the Commission in the administration of this title means that the Commission has in any way passed upon the merits of or given approval to any trustee, indenture of security, or any transaction or transactions therein, or that any such action or failure to act with regard to any statement or report filed with or examined by the Commission pursuant to this title, or any rule, regulation, or order thereunder has the effect of a finding by the Commission that such statement or report is true and accurate on its face, or that it is not false or misleading. Penalties. Sections 325. Any person who willfully violates any provision of this title or any rule, regulation, or order thereunder, or any person who willfully in any application, report, or document filed or required to be filed under this provision of this title or any rule, regulation, or order thereunder makes any untrue statement of a material fact or omits to state any material fact required to be stated therein or necessary to make the statements therein not misleading, shall upon conviction be fined not more than $10,000 or imprisoned not more than 5 years or both. Effect on existing law. Sections 326. Except as otherwise expressly provided, nothing in this title shall affect 1. The jurisdiction of the Commission under the Securities Act of 1933 or the Securities Exchange Act of 1934 or the Public Utility Holding Company Act of 1935 over any person, security, or contract, or 2, the rights, obligations, duties, or liabilities of any person under such acts, nor shall anything in this title affect the jurisdiction of any other commission, board, agency, or officer of the United States, or any state or political subdivision of any state, over any person or security insofar as such jurisdiction does not conflict with any provision of this title or any other rule, regulation, or order thereunder. Contrary stipulations void. Sections 327. Any condition, stipulation, or provision binding any person to waive compliance with any provision of this title or with any rule, regulation, or order thereunder shall be void. Separability of provisions. Sections 328. If any provision of this title or application of such provision to any person or circumstance shall be held invalid, the remainder of the title and the application of such provision to persons or circumstances other than those as to which it is held invalid shall not be affected thereby. And that wraps up, ladies and gentlemen, the Trust Indenture Act of 1939. All right, so we had to get through that because we had covered the Trading with the Enemy Act, We went into the 73rd Congress in prior videos. We went into the new definition of money, the new definition of securities, the Securities Exchange Act, the um, Bill of Exchange Act, the Negotiable Instrument Act of 1881, amended in 1882. So you know that the Bill of Exchange Act, the Negotiable Instrument Act, is the original Securities Act, ladies and gentlemen. It's so important to understand that. And we get into 1933 where they create the Securities Act, and then we go yet further into 1934 where we go into the Securities Exchange Act. And so it's just imperative to understand the differences and why they're relevant. All right. And the reason I'm sharing this Trust Indenture Act of 1939 with you is this applies to every corporation. It applies to the government. As you know, there are actually four levels to the government. We, the people, are number one, and then you have the executive, the judicial, and the legislative branch of government. Okay, but we are superior to them all. That is the beginning of the Constitution. And even prior to the Constitution, you've got the Declaration of Independence, you have the Federalist Papers, and you realize really quickly when you study the history, we are superior. Okay. And under Title 28, 3002, 15A, B, and C, the United States is a federal corporation that you are invested in. All right. And we have the stock certificate that is a power of attorney that is recognized in all courts from the highest to the lowest. And so it's just important to comprehend your power in all of this. So thanks for joining me. I hope this helps you understand some things to a higher degree. I'm going to be doing some more videos, of course, absolutely free of charge. I just want to thank all the people that make this possible, that join selfgovernanceu.com. Thanks to all your donations and contributions and attending classes and things of that nature. You guys have made this all possible for the rest of the people that are out there trying to learn. So thanks again. We'll talk to you soon. This was the Trust Indenture Act of 1939 that was absolutely important to comprehend and understand. I know I went through it fast. If you don't understand it, just go back and rewatch the videos. You guys can pause the screen at any time. You can also go through this at your own pace. These aren't secretive documents. Just type in Trust Indenture Act of 1939 and it'll pull it up. All right. Thanks for joining me, and we'll talk to you soon.